Hi, I'm Art Bergeron, and welcome back to the Elder Law 101 series that I have updated for 2025. This is episode 5, or seminar 5 in the series. For those of you who don't know me, I am an elder law attorney at Myrick. Used to be called Myrick O'Connell in Boston. We're in Worcester, Westboro in Boston. We're actually the largest firm outside of Boston. We're a multi-specialty firm. I do nothing but elder law. I like it. I'm 75 years old. My clients think I'm young. It's terrific. So to give you an overview of the topics that we either have covered or will cover, we've taken, I'll give you my make-believe couple soon, and we've taken them from when they were young, before 60, and we've talked about issues, estate planning issues before 60, and then things to consider in your 60s when you're thinking about Social Security and Medicare and all those issues, and then dealing with your 70s when you're thinking, well, maybe this house is kind of big, maybe I need to shrink down, how do I work all this? And then in the fourth seminar we broke because it was we scheduled these by month, and this was April and it was tax season. So we've talked about income tax basics for seniors. There are capital gains and income tax issues, some of which are uniquely affect seniors. Today we're going to talk about life in your 80s. The next one after this, we're going to talk about why it is you can always qualify for mass health. So a lot of this life in your 80s is dealing with protecting things just in case you need nursing home care or you need a lot of care at home, and doing some advanced planning. But if you haven't done anything and you're tuning in right now because, oh my God, this is a disaster, then you probably want to watch the next seminar, the episode number 6, which really talks about why you can and maybe want to always qualify for mass health. Number 7 is just going to talk about the last year of your life, a very important year. We're going to just kind of talk about some options for that. 8, the next seminar is going to talk about dealing with the things you left behind, whether you left them behind individually and they're going through probate, or you left them behind in trust, or you named somebody as a death beneficiary, all the issues that get dealt with after you die. Then I'm going to do one seminar just about trusts, because inevitably people come in to me and they talk and they say, I really need a trust. And I'll say, well, why is that? And they'll say, everybody's got a trust. Well, what kind of trust do you need? Oh, I don't know. I just need a trust. So the point is, we're going to talk about revocable, irrevocable, testamentary versus living trust, all those issues, what the problems are, and what the trust solution is, if there is one for you. We talk then all about the kids and the grandkids. After you've died, where are these assets going? And do you need to protect them somehow for the benefit of your kids and your grandkids? 11, we're going to talk about Medicare, which we all have to deal with pretty much from your 60s on. And finally, 12, which is the December presentation, tis the season. We talk about giving, but we also talk about tax planning, because there's a lot of things that you maybe want to think about doing in that last month of the year. So if you're in your 80s, then you would start needing to deal with frailty. And these are my friends Frank and Mary, whom we've covered all the way through this series. They have 3 kids. They have kids named Peter, Paul, and Mary Jr. And their goal in life is very simple. They want to live in their house until they die. They want to be buried in the backyard. If they're 80, though, death is getting a little kind of close now. Frank's life expectancy at 80 is 9 years. Mary's life expectancy is 10 years. And so the estate planning for them has become much more real, because death has not become a matter of if, but a matter of when. And by the way, there were their kids, Peter, Paul, and Mary Jr. Once again, their goal in life is very simple. They want to live in their house until they die. They want to be buried in the backyard. Oh, that we could all be so lucky. I also talk about Mary's sister, Peg, and her daughter, Peggy, or Peg Jr., because often when I would do these seminars in the past, inevitably someone would come up to me from the audience afterwards and say, well, this isn't relevant to me, I'm single. Well, that's why I included this character. I mean, because Peg's situation as a single person is very similar to what Mary's would be after Frank dies, but we're going to talk about that. So Frank and Mary's assets, I talk about their assets in 2 places, because these are the 2 places where I would traditionally do seminars, and where therefore you may have heard of me. If we're in Metro West, then Frank and Mary have a house worth $400,000. Frank has an IRA worth $400,000. They have joint savings of $300,000, so they have total asset value of $1,000,001. This is not an unusual asset configuration. If they live on the islands, either Martha's Vineyard or Nantucket, where I go every Thursday, it's always Island Day, and I get a lot of grief for this during the summertime. Oh, where are you working today? You know, but the point is, my clients, there's this myth that there's a lot of money on those islands. The money flies in, the money flies out. My clients are the local folks. So once again, they have a house. Frank has an IRA with $400,000, and there are joint savings of $300,000. And by the way, in both of these cases, Frank's Social Security is $2,000 a month, and Mary's is half of his, or $1,000 a month. The difference, of course, is they're on the islands, and so their house, with the very same cape that they have here, that's worth $400,000 here, is worth $1 million on the islands. It's actually worth a little bit more than that on Nantucket, but we're assuming that it's worth $1 million, so their total value is $1,700,000. So the question then is, what happens if Mary, despite her best intentions, ends up in a nursing home? If she's on Nantucket, she ends up in our island home. If she's on Martha's Vineyard, she ends up in Windermere. If she's in Metro West, she ends up in a whole variety of different places. The point is, in all of those cases, if she's in a nursing home on Medicare, that Medicare is going to stop after no more than 100 days. And after that, she's going to be on private pay. And the typical private pay cost around here is now about $17,000 or $18,000 a month. Yes, you heard it right, $17,000 or $18,000 a month. This is a big number, which she's going to be paying until she qualifies for Mass Health, which she can qualify for. Mass Health is the Massachusetts name for the Medicaid program. She can qualify for Mass Health. In order to qualify, she has to show that she has less than $2,000 in countable assets. But Frank, because they're both still alive, and Frank is living at home, can own the home, no matter what the equity. So going back to that house on the islands, he can own that home, even though it's got a value of $1 million, right? He can have other assets of worth up to $157,000. This number changes every year. And he can have unlimited income. Therefore, if Frank came into me because it was an emergency, Mary was already in the nursing home, I would tell him, no worries right now, this is all okay, as long as you have a power of attorney from Mary, or someone does, that gives that person the ability to give you the assets, to give the assets to the spouse, you're all set. Because all you have to do is we're going to shift all the assets to you, because you, Frank, can own the house. You can have up to this $157,000, but then what we're going to do to deal with that extra money that you have is we're going to have you buy an annuity of a very specific kind, an annuity that calls for equal monthly payments over a term that will not exceed Frank's actuarial life expectancy, which you saw in an earlier slide. It's 10 years. So the day after all the assets get moved to Frank and Frank buys that annuity, thereby reducing his remaining assets, and I would always tell him to say, keep $100,000, use the rest to buy an annuity. The day after he buys that annuity, Mary's eligible for Mass Health. From then on in, her income, which you may recall was $1,000 a month, goes to the nursing home. Mass Health pays for all the rest. So that's kind of the general strategy, right? She transfers all of her assets to Frank. There's no look back. Frank keeps, say, $100,000. Frank's other assets, there's no limit. And by the way, as I mentioned to you, he would be buying this annuity. The annuity has some specific terms to it. It has to call for equal monthly payments over a term that is shorter than his life expectancy, as I mentioned. And so Frank might be saying, well, if I buy this big annuity with these big monthly payments, soon I'm going to be over the $157,000. Well, as long as he doesn't go over that number by the time Mary qualifies, which is probably going to be 4 or 5 months after she becomes eligible, because once they've taken all of these steps to become eligible, Mass Health will pay retroactive to that date of eligibility, as long as Frank on Mary's behalf applies for Mass Health by the last day of the 3rd month following the date that he took all of these steps. So by that time, he will have received several of these annuity payments, these monthly payments. But as long as the total value that he has at that point is still below $157,000, and Mary therefore qualifies for Mass Health, the day after that, he can hit the lottery. He can have unlimited income. So by purchasing, that's why we would never recommend that Frank keep $157,000 and buy the annuity with the rest, because we'd be concerned that as a result of these annuity payments, his assets would grow to more than $157,000 before Mary qualified for Mass Health. So once again, the Medicaid qualifying annuity has to be irrevocable. It has to be for a term that is shorter than Frank's actuarial life expectancy. And here's one of the kickers. There are two things that are troublesome about these annuities, right? First, if Frank dies before the end of the term of the annuity, remember it can be for as long as 10 years, but it can be shorter than that. And if Frank dies during that term and there are still remaining payments to be paid, then instead of being paid to the children, to Peter, Paul, and Mary Jr., Mass Health is going to have a lien on those remaining payments to cover whatever they paid on Mary's behalf. So we would always recommend in this case that Frank buy an annuity with a much shorter term. The other reason for doing that is these annuities have terrible interest rates. And people will say, well, why would I ever buy one? Well, you'd buy one to qualify for Mass Health. If you talked to an insurance company and said, I want to buy this annuity, and it's got to be irrevocable, and it's got to be for my life expectancy, they'll say, oh, you want to buy a Medicaid qualifying annuity. That's what they call them. The only reason you'd buy it would be to qualify for Mass Health. Now, if you are Frank and Mary and you're trying to plan a little bit ahead for this, and specifically this is important regarding tax-deferred funds, right? Then what you may decide if you're Frank and you've got all of this money in tax-deferred funds, that you want to reduce the amount that is in tax-deferred funds every year by actually paying the tax. And if people will have tax-deferred funds, they'll say, no, well, why would I do that? I'm having to pay the tax. And that's why no one ever takes more than their RMD, their required minimum distribution. But in this case, what Frank may want to avoid is the specter of his having that stroke and needing to qualify for Mass Health and needing to shift all of his tax-deferred money at the last minute to Mary, which means that in that year, Frank and Mary's income goes from about $30,000 to about $430,000, and the tax rate on some of that money becomes very high. So as a planning matter, he may be kind of thinking about that. Frank and Mary may also be kind of thinking about how they're structuring their home, and you may want to look at the previous seminar, Elder Law for Frank and Mary when they're in their 70s, where we talk a lot about whether they want to restructure things as an alternative to simply thinking they're going to end up in a nursing home by moving in with one of the kids, by having one of the kids move in, by moving into an apartment, we talk about assisted living, a lot of other possibilities. The point is that you want to consider all of that, okay? Finally, if in Frank and Mary's case they had a vacation home and they weren't renting it out, they would need to sell it at this point in order to cause this money to turn into cash, which would then be added to the value of the annuity that they'd have to buy. What they would need to do at this point, if they didn't want to do that, nobody wants to do that, would be to start renting out the property, which they can literally do at the last minute, because if Frank owns and have the property conveyed to Frank, because if Frank owns rental property, just like if he owns his home, as long as the rental property is generating enough to cover the expenses, it's also he can own that property no matter what the equity, right? And then we already talked about the annuity, which remember you can buy at the last minute. Now, once Frank and Mary have taken all of these steps, Frank should do something else, because at this point Mary is qualified, but the only reason why Mary qualified was because Frank was alive. And so Frank may be concerned, well, oh my gosh, what happens if I die? Because my current estate plan, Frank and Mary's current estate plan is if one dies, everything goes to the other one. And I would tell Frank, in that case, what you really want to do at that point is you want to change that plan. You want to keep assets in your name, but you want to change your will to specify that when you die, any assets that would have gone to Mary will instead go into trust for Mary's benefit. And he can name Peter, Paul, or Mary Jr., all three of them, any one of them, as the trustee of that trust. The only person he can't name is Mary. In that case, if he dies, any assets that he owns will flow through this will into trust for Mary's benefit. Mary will continue to be able to be on Mass Health, or if she's not on Mass Health, will be able to get on Mass Health in the future. Any of the assets in trust can be used for Mary's benefit, as long as the trustees agree that they want to use them. So if she were in a nursing home, they'd be able to supplement Mary's care. If she's not in a nursing home, they could just be paid to Mary. But the benefit of structuring things this way from Mary's perspective is that way, if she needs nursing home care, the only money that would be counted and that she would need to spend down would be the money that was actually in her account. All the rest of the assets would be safe. Finally, for many people don't realize that there is a very good Mass Health program designed to help you stay home. Because Mass Health doesn't want you to go to the nursing home, just like you don't want to go to the nursing home because of the tremendous cost of the nursing home. So Mass Health has a program called the Frail Elder Waiver, which specifies that in this situation, say Mary, whether she had dementia or she fell and she was physically disabled or whatever, you could demonstrate that she was eligible to be in a nursing home, either because she needed regular assistance with two of the activities of daily living, which are eating, bathing, dressing, toileting, or transferring, or because she needed constant supervision because she had cognitive issues. If she can demonstrate that, but also demonstrate that she could be safe at home as long as there was enough home care, then she can qualify for something called the Frail Elder Waiver and get up to about 40 hours worth of care per week in the home if she's here in Metro West. I know that on Martha's Vineyard there's been a lot of problem trying to find people who would provide home care at the rates that the Mass Health folks are willing to provide. I know from talking to a good friend on Nantucket, though, that on Nantucket the woman there who works for the ASAP, Bay Path, our Elder Services of Cape Cod and the Islands, has indicated to me, that Sherry Hunt has indicated to me, that she has qualified people to get much more care at home in order to stay at home in order to avoid the nursing home. The main thing to remember, or two things to remember, one, that the rules for qualifying, the asset rules for qualifying for the Frail Elder Waiver are the same as the asset rules for qualifying for nursing home care. That is, Mary has to have less than the $2,000, Frank can own the home, Frank can have up to $157,000. All those rules are the same. If Mary has a lot of income, though, and I think the income limit now is $2,901, if her income is higher than that, then Mass Health is going to impose a huge deductible before she can qualify for any Mass Health benefits. So if she had that kind of income, this program wouldn't really help her. In this case, she only has an income of $1,000, so this could be a big help to her. Once again, if Peg were in this situation and I were talking to Peggy, the exact same rules apply. If she had, suppose she owned, on Metro West, say she had assets of $1.1 million, or on the islands of $1.7 million, her problem would be that she'd have a lot of assets, and because she has no spouse, she would have needed to have taken these steps in order to protect the assets ahead of time, in order for her to be able to qualify for the Frail Elder Waiver. Unless, of course, she gets married very quickly. She could get married at the last minute, and then she can qualify right away by giving all of the assets to the spouse. Otherwise, she's going to have to give the assets away and wait 5 years. If she's doing that, then the way that she would do it, probably, once again, the rule, and kind of all seniors have heard of this 5-year look-back period, this is where it applies if you're single. The rule is assets don't count against you if you've given them away and 5 years and a day have gone by. She could simply give these assets to Peggy, or she could put them into trust. If she just simply gives them regarding the house, what she would do is she would give away something called a remainder interest in the house. That is, the interest that starts after she dies. She would keep a life estate in the house, so she could keep control of the house while she's alive. 5 years and a day after she transferred that remainder interest, there would no longer be the remainder would no longer be countable or lienable. If she later needed to qualify for Mass Health would put a lien on her life estate, but when she died, her life estate would die and the lien would die with her. As a result of keeping that life estate also, when she dies, the so-called tax basis of this property will still jump to the date of death value, So when Peggy goes to sell the property later, she'll be selling it capital gains tax-free, something that's extremely important on the islands. To the extent that there are multiple children, the most common way to handle all of this is, instead of simply transferring all of the assets to your one child, which of course you wouldn't do unless you really trusted that child, would be to take your most trusted child, create an irrevocable trust, that is a trust from which you cannot take things out after you've put them in, and transfer that remainder interest in the house to the trust, and also transfer any other assets that you want to protect, because 5 years and a day after those assets are in trust, they're no longer countable or lienable in the event that you need to qualify for mass health. So the goal of all of this, as I try to always emphasize to clients, is peace of mind. You get to our age, fame and fortune have passed us by. You just want to get a good night's sleep. So if you're not worried about this, no problem. However, if you're in your 80s or you have relatives who are in their 80s, they should be thinking about this stuff, because it is, as I've suggested, especially if you're dealing with a single parent, their options are much more limited unless they really planned ahead of time and dealt with this 5-year look-back period. But if it is an emergency, they can still qualify for mass health. There are more constraints on them. If you want to learn more about that, you really ought to watch the next seminar. So thank you very much for watching. If you have any questions, you can always go to Frank and Mary's YouTube channel, Elder Law Frank and Mary, or you can reach me at my office at that phone number or at that email address. I'm always happy to talk to folks. I never charge for advice, which I love to give. I look forward to seeing you on the next installment of Elder Law 101. Thank you very much.